right?
Red is off, yes. Let's see, is this is working? Okay, all right.
Recording in progress.
All right, I would like to call to order this meeting of the Planning Commission, which I think is probably the last one of 2024, although we could be surprised. No, oh, we're getting a nod. Okay, all right. Hope springs eternal. And so, Taylor, can we call the roll and establish a quorum?
Yes. Commissioner Ahi?
Here.
Commissioner Disney?
Here.
Commissioner Mensinger?
Here.
Commissioner Roche?
Here.
Vice Chair Beninado?
Here.
Chair Steinle?
Here.
We have a quorum.
Thank you. And for those who may not have got the news, we have only 6 commissioners at present. There will be an attempt to get a 7th commissioner coming up, but for the moment, we have the full complement today.
I have a question. Did someone leave or resign?
Well, Shelley Doran decided not to apply for reappointment. She has dreams of going elsewhere.
Okay,
And
so she turned out?
no, she simply decided not to reapply. She had one term and she has other ambitions.
Her first 4-year term ended.
Right.
Okay, chose not.
She chose not to reapply. And at the city council has not chosen anyone to replace her. So the idea is to get there at some point as soon as possible. Okay, the first item on our agenda would be for any public comments on items not on the agenda. We do have one member of the public, so if he wishes to speak on an item not on the agenda, now would be the time. And if he doesn't, he can shake his head and, okay, all right. Then in that case, the next item is item 1 on our calendar, which is the consent calendar, and that is to review and approve the minutes of our April 18 meeting, which I trust you've all reviewed. Are there any questions or comments about that? No? Okay. Then I'm going to move that we approve and accept the minutes. Is there a second?
Second.
Okay, it's been moved by me and seconded by Commissioner Mensinger that we approve this. Taylor, if we can have the...
Commissioner Ahi?
Yes.
Commissioner Disney?
Yes.
Commissioner Mensinger?
Yes.
Commissioner Roche? Yes. Vice Chair Beninado?
Yes.
Chair Steinle?
Yes,
Motion carries unanimously.
thank you. And the next item on our agenda, item number 2, is the election of a chair and vice chair. I will take a moment to be reminded of a cartoon I saw many years ago of a bunch of cavemen standing around, and the group says to one of them, tribe member so-and-so, in view of your many years of service to this tribe, the Council of Elders has decided to let you make a run for it. And in that spirit, I am now going to open, I get to say things like that at the end of my term.
Or at any other time during your term. I may
True,
point out.
true, yes, right. I didn't want to give anybody ideas.
Yeah.
So I now am going to open this to the election of the chair, and I'm going to take advantage of my position to nominate our current vice chair, Joe Beninado, to be the chair. If there are any other nominations, now would be the time to make them. I don't hear any. So,
Do I need to accept or?
well, you could say yes if you want to do it, yes.
I accept.
Okay. We should go ahead and have a vote, or do we just, yes, we go ahead and have a vote. All right, so Taylor, if you can call the roll.
Commissioner Ahi?
Yes.
Commissioner Disney?
Yes.
Commissioner Mensinger?
Yes.
Commissioner Roche?
Yes.
Vice Chair Beninado?
Do I vote on this?
Yes? Yes?
Yes.
Chair Steinle?
Maybe. No. Yes. Okay. And with that, then I'm going to make a run for it, and we're going to switch seats.
Okay.
See, there was a theme there.
Yeah, now I get it.
Yeah.
Here, I'll let you grab your sweater.
Yeah, I will. If you want to sit down, I will. Okay.
Wow. You good? All right, let me get my stuff out.
Yes,
Oh,
he's just justifying his presence.
is that me? Thank you, Mayor. Good idea. Let's see. I wrote up some stuff in case this were to happen. Okay, well, first of all, thank you for the confidence from all of my colleagues. And I'd like to thank Chair Steinle for his work this past year, even though he got half the year off for some reason. And I hope to follow your excellent example as well as the examples I've seen from some of my colleagues. So our next order of business is to select a vice chair for 2025. Do we have any nominations for vice chair?
I'll nominate Richard.
Okay, we have a nomination for Richard Roche. Do we have any others? Okay, well, then I guess we'll take it to a vote.
Commissioner Ahi,
Yes.
Commissioner Disney,
Yes.
Commissioner Mensinger.
Yes.
Commissioner Roche. Vice Chair Steinle,
Yes.
Chair Beninado.
Yes. Motion carries, I guess, or the nomination carries. So congratulations. Do we need to switch more chairs or are we good? All right. All right. Great. And well done, Taylor, on switching the vice chair and chair titles on the fly. That was very well done. Okay, so congratulations to Richard, and we're going to move on to the public hearing, right? And guys, if I screw this up, let me know. I'm sure Nick will for sure. So.
You won't have to.
So our next order of business is a public hearing on staff's recommended zone text amendments to Los Altos Municipal Code Title 14. And for those who don't know, our public hearing procedure is to receive staff's oral report, which supplements the written report that is in the meeting packet. Commissioners may then ask clarifying questions about the matters that are in either the published report or the oral report. After questions, we'll receive public comment on staff's recommendation. And after we receive public comments, I'll close the public portion of the hearing and we'll move on to the motion, commission discussion, and the votes. And I plan to adopt former Chair Steinle's approach where we'll put the motion on the table and then we can discuss it and debate it and modify it if we would like to. I think that worked pretty well the past year. And
I have a question. So we do not give our comments.
do you want to use the, yeah.
We do not give our comments prior to the motion being made because I went through the handbook today and that's not what the handbook says.
And I did as well. And what I was told was that there was a discussion last year with Jolie and who else? And Nick. And that the recommendation in the handbook is simply that. But you can do it in whatever order you want to. So
Okay.
are
I just
you,
do
do you prefer the other way? Or?
I actually do, but I'm willing to defer to what you'd like to do. I just wanted to make sure we weren't in violation of the guidelines.
No, and I saw that, and I was a little I'm like, have we been doing it wrong the whole last year? But so Jolie, do you have a comment on that, or not necessary?
Yeah, it's just that the norms modified Rosenberg's where you have to have whatever that, it's in that appendix where the council amended that, where you don't need to have a motion before you do the discussion, but that is something that you can choose to do or not to do. I think that's what
And
we
one
came-
other practical question. Last year, at our last meeting in April, we had screens here, which made it a lot easier to see the staff presentation. Are those now gone with the remodel?
So the screens were transitioned over the summer for the city council, and then we actually just realized is that our IT only set us up for 5. So we just put in a ticket for them to set up another 2. So there wouldn't have been enough for everyone. Tonight's presentation, there's actually not going to be a PowerPoint. That's why we gave you guys the printed packet for tonight for the zone text amendments. So it will be a little bit different for this one, but we should have it all resolved by the next meeting.
Okay, because that's kind of far away to really read a
Right.
PowerPoint from.
Yep,
Okay. At least for
exactly.
some of us.
Yep.
All right, so why don't I invite staff to present item 3?
Sure. Good evening, Commission. So Assistant City Manager Zorns. I am going to kind of briefly go over the background of what's before the Commission tonight and then open it into questions. Tonight's item is kind of quite dense because it's more practical in regards to the implementation and facilitation of zoning standards within the city. So as I've outlined in the staff report tonight is the municipal code does contain several regulations, what we see for development standards, building heights, setbacks, so on and so forth. However, what we don't really explicitly outline are provisions and for process and procedures. Everything is fundamentally outlined in California planning and zoning law. However, we don't really have some of those segued or applied in our zoning code just for kind of easy, application and reference. So fundamentally, that's what this entire zone text ordinance does. The one thing that I will say is in the section for the chapter that relates to our zoning definitions is that's been kind of an ongoing, I would say almost like hit list of definitions that have been requested by staff over the last 2 years. Didn't want to kind of bring them, one by one, obviously, as they've come up. We could have. However, it was kind of a big compilation of the variety of definitions that we don't have. One of the main reasons, as simple as it might seem, is when you don't have the zone text for definitions, you often are in conflict, sometimes in kind of like a little bit of a rub with the development community because we don't have something that explicitly defines what we're essentially trying to apply from time to time in the zoning code. So with that, though, the administration of zoning is kind of the bigger, dense portion of our zoning ordinance. It really kind of just explicitly outlines the administration of the zoning code, especially with some of the newer terms. My title, which is interchangeable between Development Services Director and also the Zoning Administrator, as I still serve as both of those appointed positions by the City Manager. How we actually process discretionary applications and the actual review procedures. The city also does not have explicit requirements about expirations and extensions. We do make some references throughout the code, but not really explaining explicit criteria. We do oftentimes, as a condition of approval, provide specific requirements about expirations or extensions. However, that is essentially on a case-by-case basis. When we do approve a discretionary project, it's best practice for us to have that built into our code so that people understand how it's being applied. Also, there are some specific provisions about fees and deposits. That's something that we do need to have in there for especially development applications that come in. People start the review process and kind of expect or want an entire refund after staff has spent several hours from planning, engineering, building, doing the reviews. The city does need to recapture some of those fees that are incurred, and we're not really able to fully do that as explicitly as it's now going to be contained in the ordinance. Additionally, amendments and modifications to discretionary applications. This helps to provide some pretty explicit criteria about how amendments can be processed in the future. One thing that we also do lack is general zoning provisions for amendments to land use documents. It is contained within planning and zoning law, as well as when the council does adopt the hierarchy of a land use document, such as a general plan, like the housing element, that then authorizes staff to be able to bring the subsequent amendments to the implementing ordinances. With that, though, is if we have a private zone text amendment, we really don't have essentially the explicit criteria outlined about who and when those can be brought forward and how we actually process those. So this will actually help to fundamentally outline that to the public when we do have private zone text amendments. We actually will have one later this year or early next year from an interested party. Additionally, preliminary reviews, we do have some language actually already in our code in other sections, but it's just a high level reference to what is allowed as a preliminary review. Additionally, we also just have general appeal procedures contained in our municipal code, which is not really consistent specifically for land use decisions. You usually have some specific criteria that's pretty explicitly laid out in the code for when those appeals happen and who is then the reviewing body, so that not everything is immediately getting elevated to the council when they should be able to stop at the next higher level review body. It essentially does provide that level of separation and kind of the continuance of essentially potential local challenge to be able to give people that that full scale of review. Additionally, we do have a clause and section for revocation of and modifications of entitlements. This is also very important for us to have something explicitly outlined in our code that can authorize the local action rather than having to refer it to the city attorney for judicial review. That helps us to also, again, maintain kind of the local process and due process of showing that we're kind of going through all of the steps and provisions locally first before referring it to a higher court. Additionally, we also don't have a best practice of administrative modification of standards, or what sometimes we call AMS in practice and planning. And this is essentially for a small deviation of something of 10% or lower of a criteria of something like a fence height when you have grade differentials. Essentially, if someone needed an extra foot of height, we'd have to go through the entire variance process and go to this body, which is a little bit extensive and a little bit overkill for something so minor, but we do have those grade differentials from site to site. So having that essentially administrative modification allowance does help us to kind of streamline a little bit of the review process. Additionally, we do have kind of bifurcated sections of public notice requirements throughout the zoning code. It should be in one contained section and then referenced back so that it's all consistent throughout. We don't really want there to be slight deviations about what the public notice requirement is, because that is something that's contained in the government code 659091. And so really we shouldn't be kind of modifying and manipulating it for certain sections when it's not consistent with law. And then the last kind of three provisions is indemnification of the city. This helps to further indemnify cities that get approvals of their entitlements or that are getting processed for entitlements. Clause for public projects. This is actually verbatim already in our code, so we're just continuing that and reorienting it from one chapter to another. And then also a clause for no relief from other provisions. So a lot of times development will occur and they think that the zoning code essentially will get them out of jail with the with essentially an EV requirement in the building code. So essentially you're meeting the zoning standards, but then you also have to meet all other standards, and that's really what that clause essentially covers. As I mentioned, there's obviously the zone definitions. which is obviously pretty self-explanatory with which ones we have amended or added. And then also an explicit variance section. We also kind of run pretty lean on that in our zoning code and just refer back to the government code 65906. So everything is outlined in the government code, but we really should have some of the basic applicability and process procedures for staff to kind of easily be able to refer to and help the public with. So again, I know that was very dense. It's obviously kind of hard to put onto PowerPoints for this type of a code amendment. Since these are all kind of things that we're already doing, it's just now, as the staff report says, is we're kind of memorializing it actually into the text versus by reference or in procedure manuals that staff reference internally. But I do have, if you have any questions, I'm available.
All right. Thank you for the excellent report. I'll invite, do you have a question before or as part of? Okay, I was just going to open it up for clarifying questions. So we're focusing on clarifying either the oral or the written report. Go ahead.
Do we have a lot of discretionary and variances requests for those?
Is the mic on?
Sorry, we have requests for a lot of requests for discretionary applications and or variances? Just a general question.
So we, I think the commission knows that we received one approximately like a year and a half ago. And then we had two others that were initially considering a variance, and after a consultation with us and really kind of painting the picture of what actually variance requirements are required to be met, because regardless of what the zoning ordinance ever states, everything still is subordinate to the government code 65906. And so after kind of explaining it to them back and forth of that, they kind of decided to not go further with it. So again, it's kind of a best practice to kind of outline it into our local code. So we don't really have too much discretion because the requirements or what's allowed for a zoning variance it's all contained within state law.
All right. Other questions from either side? Go ahead, Commissioner.
Just a quick question. It sounds like this will make it more straightforward for both staff and applicants. Is that a fair way to summarize this?
That's correct. Yeah.
Anybody else?
Are we asking questions about the entire document?
Yeah.
Not just the first part?
Yeah, clarifying questions on the written or oral report.
Okay. Just to clarify with variances, it looks like in what's written here in 14.81 that variances go to the planning commission.
Variances do, yes.
So is that sorry. So all variances go to the planning commission?
Yes.
Okay. All right.
Any more questions?
No.
Okay, I have,
Thing about variances, and Nick's going to be mad, but variances are, it has to be something very unique and special about the property, so you're not granting a special benefit or exception. And the other thing that I always have to advise is it runs with the land, not the applicant. So like a use permit, it runs with the land, and you may think this is the best applicant ever and you want to do it, but you can't make those findings. That's not a finding for a variance or a use permit, because they do run with the land, so the next owner gets that benefit as well.
great. I have a few myself for Assistant City Manager Zorns. There was a public comment by Jim Wing about objective design guidelines for substandard lots. Is that something, I thought you might be addressing that, or did you address that and I missed it, or are you not addressing that?
So I didn't address it in my oral presentation. So I actually have also communicated with Mr. Wing, who's here for public comment after our questions.
Oh, okay.
But I will say what I communicated to Mr. Wing, and it's also just for information sharing, is in the new year, we will be bringing forward a zone text amendment for substandard lots, which will also specifically incorporate the irregular shaped lots as well as shallow and narrow lots. Again, those are some things that we usually can kind of somewhat figure out and finesse a little bit with the development proposal, but there are the cases where you simply need some type of a relief, and it shouldn't have to go all the way down the process of going through a variance. If it's something that's a kind of a known abnormality with a lot. There's other jurisdictions that have also incorporated that as a standard standalone chapter. So we're working on that for another chapter. So it doesn't need to necessarily be integrated into this one.
Great. I have a question on page 34 of the packet, which it's 14.01.080, amendments to land use documents. All right, let me know when you're there.
080.
Hopefully the pages numbers didn't change.
08. Yep, go ahead.
Section B1, little b, the zoning administrator will take the written request to the city council for consideration. I was wondering why it wouldn't go to the planning commission first before it goes to the city council, because later on the next page it references planning commission recommendations. So I was confused between the difference there.
So the planning commission doesn't have the authority to authorize a private zone text or general plan amendment that resides with the legislative body. The planning commission is only quasi-judicial. And then the recommendation is also, again, the planning commission does not have the ability to authorize the legislative action of the jurisdiction. You are making a recommendation to the legislative body to then further adopt.
Okay,
This is like a gatekeeper clause essentially
It's fine.
for that's how the commission will act.
that makes sense. And so then on the next page where it talks about the planning commission recommendation, that's with regards to zoning code amendments, which is essentially what we're doing right now.
What you're doing tonight. Yes.
Okay. All right, perfect. Next one, page 38. It's, let me see. What's the number? It's on the previous page. 14.01.120, administrative modification of standards, item B1. It states at the end of that item 1, reductions shall not be greater than 10% of the standard being modified. So I wanted clarification on, this means that if there's a setback or, floor area number or something else, that the zoning administrator can veer from that by up to 10%. Is that accurate?
Yes.
Okay. I was not aware of that. That is super helpful. Okay, and then the last one is on page 39. And it's 14.01.150, where it basically says that the city does not need to adhere to zoning regulations. And I wanted some clarification on that. Is that accurate?
It's in the state law.
Yeah, so it's in state planning and zoning law. So even if we don't have it, again, this is more so for transparency and public disclosure, is that contained within state planning and zoning law, a jurisdiction that owns or is facilitating the production of their own development within their own jurisdiction is not bound by their own zoning regulations. So again, this is actually the subsection that I was talking about that's actually already in the zoning code verbatim. We're just moving it from chapter 14.02 to 14.01 so that it's essentially consistent in the administrative section of our code.
I have a follow-up
Yeah,
on that.
I mean,
Okay.
we still usually follow the process. It's just there's some abnormalities when you might need it in the future. And it's, again, we don't have to have it in the code in order to adhere to it. This is, again, just for simple application and transparency.
Yeah, I wasn't aware that that was possible. Go ahead, Commissioner
Isn't that
Menzinger.
also true for the schools?
Yes,
Schools
it-
can basically do anything
It's
they want on their property.
I mean, we're essentially the same as the schools. We just don't have to go through the state architect's office to get approved, where they do because of the public health and safety concerns with having a large space with children. So it's the same kind of premise.
But they could put 25 portables on one of their sites
And real ugly signs, too.
And real ugly signs, and there's nothing we can do about it, correct?
Yeah, and, yeah.
Yes, that's true.
All right, any other questions before we move on?
I do have I want to come back to the variance thing. So.
Speak into the mic.
Variances?
It's on, it's on.
Okay. Okay. So all variances go to the planning commission, but then you can relax the rules by 10% at the staff level. So I'm wondering how that isn't a variance if you do that. If a setback is 25 feet and you can shave off 10% of that, and you have you have discretion to do that, how is that not a variance?
What section are you on?
Well, I'm referring to the one, you know what, I'm going to have to go find it now because I don't know where it is.
Commissioner Disney is referring to the administrative modification of standards, which you were referencing, Joe, for the 10% reduction.
Yeah, what page is that on? Sorry.
The 10% question I had was on page 38. But that, I don't know if that was that variance?
No, Commissioner Disney is asking how an AMS is not a variance.
Right, but it says the zoning administrator shall have the authority to approve, conditionally approve or deny an application for an administrative modification pursuant to the following limitations: reduction of required lot area, minimum floor setbacks, so forth, right? So if you were to change the setback by 10%, isn't that like a variance?
Yeah, there's some jurisdictions that actually don't call it administrative modification of standards. They call it a minor variance. So, I mean, it's really nomenclature to kind of be able to keep them separated so that you don't really have people just thinking, okay, we'll make a request for anything. It's really, we're making essentially a predetermination that there is some a specific class of certain standards that have a maximum threshold of a 10% deviation that the city's okay with to use on a case-by-case basis. That's why you set the threshold so low at like a 10%. I've not ever seen it above 20%, and I wouldn't be recommending 20%. I think that's too generous. I think you're then starting to push to actually modification of the actual development kind of allowances or requirements. But yeah, it's just a nomenclature kind of reference.
So what do we call that kind of variance?
So we would be calling the 10% or less the administrative modification of standards.
Okay, so it's not, we're not calling it a variance.
Correct.
So it's called administrative, say it again?
Modification of standards.
Okay, so it's not called a variance. So then, in the section under variances, only planning commissions approve variances.
That's correct.
Okay, so then why does it say a variance may be, this is on page 60. It says a variance may be granted provided that the zoning administrator or planning commission finds after a full investigation and public hearing that all of the following are true. So that to me makes it sound like the zoning administrator can approve of a variance.
So your question is, why are there two of them, or what is your question specifically?
Okay, so we just said that only the planning commission approves of a variance, or the city council could, if an applicant appealed what the planning commission decided. So if the zoning administrator cannot approve a variance, why does it state in 14.81.040, a variance may be granted provided that the zoning administrator finds
Right.
after a full investigation and public hearing that all of the following are true. That seems to imply that a zoning administrator can approve of a variance.
Well, the,
Yeah, it would as it's written. We can remove it. The thing is that the zoning administrator only reviews development of 5 units or lower for residential development. So it would never be for a project in downtown that's one of our bigger mixed use or residential development. So if the it is written that way, yes. Now that I see this section, so yeah, the existing provisions are only to the planning commission. But if the planning commission wants to leave it as drafted, or they want to strike through the provision to allow the zoning administrator, that's fine too.
all right, so we're not going to get into discussion now, but are your questions answered? Your clarifying questions?
Well, there was a little bit of fuzz in that answer, but I just, so it doesn't matter what you're reviewing or what, I mean, it's all projects, whether they're 4 units, 5 units, single family, all projects that are variance applications come before the planning commission.
So no, the answer still stands is that the zoning administrator does not have the authority to review design review applications for units of 5 or more. So I do not review anything with bigger than that. It would go to the planning commission because then it's considered a multifamily development for design review.
Nick, if you were to strike the zoning administrator from that provision,
We're not,
it's a question.
Okay.
Joe. If you were to strike the zoning administrator from that provision, are you fine with how it would read then?
It would. What it would do though is is it would bifurcate the review. So the planning commission would, it will be an awkward review, to say the least. The planning commission would not review the design review permit for a development of 5 units. You would only be reviewing the variance that I've already taken final action on the design review for. So actually, for consistency purposes, it should be less, as I've already been designated as the authority for 5 units or less. So otherwise, you're gonna almost have to make the decision on a variance. If I've essentially made the findings for a design review, I wouldn't really be making, I'd be recommending the approval of a variance for the units of 5 or less.
Yeah, because I understand your question, Kate, about using the language variance when we've just been told it's not a variance when done by the zoning administrator. Am I summarizing that correctly?
Right, I mean, and yes, and I think, most applications probably come to the city and they're not requesting a variance.
okay,
So-
I think we veered into discussion. So if there are any clarifying questions, we can address them now. Otherwise, we bring it up during discussion and then we debate if we want to change that.
Except I think it is a clarifying question, Joe, because I'm trying to understand how this could be, if the drafting such as it is needs to stay or not stay. That's really a question. It's not a comment. At least that's the way I.
So I'll clarify. If it stays, I will take final action on of a development of 5 units or less, which has already been authorized by the city's adopted housing element for the actual design review. You will then essentially have to take final action on a zoning variance, which is essentially almost going to be like preliminarily decided. It would kind of be an awkward review.
Okay. Thank you.
Okay, any other clarifying questions? Otherwise, we will move on to the public portion and we will come back to discussion. So I will now open the public portion of this matter so we may receive public comments. Are there any comment cards?
For item 3, no.
Item 3, exactly. Okay, last call. So no public comments, and we're going to move forward, and I'm going to state the motion that staff has recommended that we adopt, discuss, and approve. It's on page 22 of the staff report in our meeting packet, and it states, the motion recommended by staff is to introduce and adopt the proposed ordinance number 2024-whatever, which includes the addition of chapters 14.01 and 1.81 and amends chapter 14.02 of the Los Altos Municipal Code and to find that the proposed amendments are exempt from environmental review pursuant to Section 15061B3 of the California Environmental Quality Act, CEQA guidelines. So any commissioner who would like to propose this motion may do so by saying so moved.
So moved.
Okay, moved by Vice Chair Steinle. Is there a second?
Second.
Okay. Okay, Commissioner, both of you are at the same time, but we'll give it to Commissioner Mensinger. And now we are going to discuss the motion. So I'll just remind everybody, our discussion and debate should focus on what is in the published agenda, not stray off of the agenda. And there will be opportunity later in the meeting for commissioners to propose future agenda items. So we'll start the discussion. Perhaps we want to talk about variances. Would anyone like to kick us off?
You know what, can I make a suggestion? Because I really liked the way we did this before. We just kind of take it page by page, because it's a lot. And there's some really nitpicky grammatical things that I don't want to, I think it'd be very helpful to just go page by page. That's my vote.
You guys are really working me tonight.
Can I ask, Kate, are you talking really truly about grammatical changes as opposed to substantive changes? Because I think grammatical changes we can just provide to staff outside of the meeting.
I prefer not to go page by page and group edit a document. So what I'd like to do is discuss any issues and debate any issues that you have. If you want to go page by page and bring up 20 issues, then that's fine. But any grammatical stuff should be taken care of in advance, or after the meeting you can say there's a typo in section whatever. But I don't see the need for us to go through this page by page, and that is just my bias. So do you have specific issues that you'd like to bring up?
Well, sometimes I wonder if what I think is a grammatical error means something else. So but that's fine. I can just give them to staff. That's fine.
Okay, well, so do you have any issues you'd like to discuss?
Well, I'm going to go through it because there's a lot, and I'm just going to look through it, okay?
Okay, would you like me to come back to you, or you want to do it now?
No, I can do it now.
Okay.
Okay, so there's no definition of ministerial, administrative, and discretionary in here, and I just want to just kind of understand. So when staff says ministerial, does that mean that it is a non-discretionary application that goes to planning staff? Is that what that means?
What page are you on?
First page 30, which is the first page of 1401. It's the first page of...
Page 30?
It's chapter 14, it's the first page.
So ministerial is the process for anything that is allowed explicitly in the zoning code and does not require a discretionary action. Administrative is a discretionary authority that is at the staff level. And discretionary is something that would have to go to a hearing body at a publicly noticed meeting. So the zoning administrator, planning commission, historic commission.
Okay, that's very helpful. So an administrative action is discretionary.
It is discretionary, yes, but it doesn't go before a hearing body
Okay,
because
but
it's.
no hearing.
Correct.
Okay, so whenever we see the word discretionary in here, it's something that could be approved at the staff level, or it could be approved by the planning commission, depending on the type of project that it is.
Yes.
Okay, I think that's very helpful. I think, I don't know, I think that'd be helpful to kind of clarify that.
How would you suggest?
The way he just said, I think would be very helpful. when we're talking
Could you
about-
repeat how you were going to do that, Assistant City Manager?
So
Or
I
will you-
mean, we would just add a definition in, we would add a definition about what a ministerial project is, what administrative project is, and then what a standalone discretionary project is, meaning that ministerial means it's something that's allowed explicitly in the zoning code by right, essentially, and then administrative is a staff level administrative review and approval with no public hearing, and then a discretionary entitlement review is something that goes to an appointed hearing body.
And would you suggest we do that?
We can. I mean, again, those ones are kind of stuff that, I mean, they kind of somewhat almost sometimes get used interchangeably, but we can define what they mean, yes.
Okay. Should I poll everybody on how we feel about this one, or should we come back and do them all later on?
Let's poll now.
Okay. What?
I think
Why don't you speak into the mic, sir?
I think this is a proposed amendment.
Yes.
Yeah. Okay, well, that's either by friendly amendment or by motion.
Okay. Well, I was going to see if there was support for that, but do we want to do that now or come back to them? Why don't we come back to it? So I'll flag it as so definitions of ministerial, right?
Yep.
Okay, we'll come back to that and see if the
Well, definition of
proposer and
minis-
the seconder would like to accept that change. Go ahead.
I think definition of ministerial, administrative,
Right,
discretionary,
right.
what those mean when people read them.
Yes.
Now I'm thinking there was something else in here that says that the staff can have a hearing. So if the staff is doing a discretionary review, is there a hearing? Is there ever a hearing? Or is that only if there's I mean, I'm sorry, I don't know exactly where I read this because it's awfully long, but I know I read something in there that says the staff does from time to time have reviews. Is it a public review? Or public hearing?
I believe the zoning administrator does hearings which are noticed. I get them.
Right, so then,
I want to clarify, I'm not staff though. When I act I am a hearing officer of the city of Los Altos, and it's defined in our code. So in the administrative section of the municipal code, it's been in there for over 2 decades. So the zoning administrator does serve as a hearing body. It's the lowest level land use authority when it comes to a hearing body though. And then below that is the staff level. So there's essentially ministerial is at the counter, getting an over-the-counter permit from planning. Administrative is essentially 500 square feet or less of an addition or modification of space, requiring a design review. And then anything above that either triggers the review of the zoning administrator or the planning commission. Previously served as the Design Review Commission. So actually, the majority of all these regulations, the Planning Commission has not seen for over 10 years.
Okay.
so
So-
just to be clear, the zoning administrator might have a public hearing.
The zoning administrator always has a public hearing.
Yes.
But again, you have to, the zoning administrator is not staff.
Okay, sorry about that.
Yeah,
So an administrative review is a discretionary at the staff level.
correct. For essentially a design review permit of 500 square feet or less.
Okay, so, and then there's then a discretionary could be the zoning administrator and a public hearing, or the planning commission and a public hearing.
Correct.
I mean, I don't know about you guys, I think a chart would be very helpful to kind of break this down.
Kate, if I can help, discretionary means a judgment has to be made.
I understand
Okay,
that, yeah.
and then however the judgment is provided here, it's discretionary. So I think that's fairly clear.
All right, I feel like we're going back into the clarifying questions section of the event. So do you have topics you'd like to discuss and debate, or do you have a series of clarifying questions that you'd like to go through? Commissioner Disney?
I guess they're clarifying questions. They may not, I mean, it may be, I don't want to debate if they're if we can wait for that, but I do have some clarifying questions.
Okay, we have this issue regularly, so you have to bring these things up at the appropriate time. When we're in the clarifying questions section, that's where you bring them up. So how many more clarifying questions do you have?
I don't, I've got a couple of them, so.
Okay, please proceed.
Okay, so one of the clarifying questions I have is on the second page of the 14.04, I guess it's page 31. And there's, my question is, it says a city official may enter any premises, buildings, or structures at any reasonable hour as long as they can get consent of the owner. And so my question is, would having that in the code could potentially be a problem if the occupant of this structure is a tenant and not the owner? And the tenant didn't give the city permission to enter the premises, but the owner did? I mean, is that a concern for the city or a risk to enter a property that is occupied by a tenant who didn't give them permission to enter the property?
That is under development?
No.
No, it's just section 14.01.010, section D1 on page 31. It talks about that a city official may enter any premises.
Yes, I see it.
Okay, so what happens, again, if the owner of the property gives the city the right to do that, but the person occupying the property is a tenant and didn't give the city the right or permission to come into the property? So is there any risk to the city the way it's written?
I think the intent of this is the planning commissioners, and this is even in, and I should have brought my government code, but that planning commissioners have a right to go out and inspect properties that are coming before them. So you can go out and look at the property, look at the building that's going to come in. And if the property owner or the tenant says, no, you can't come onto my property, you have to look from the sidewalk, I think that that's what the planning commissioner would do. But it's to allow personal inspections of a property that's coming before the planning commission. Like you want to see where the trees are, or you want to see where the setbacks are. But that's even in state law.
Yeah, so I mean, I guess the concern of having, whether or not you have the property owner's permission or the tenant's permission is, I mean, if let's say code enforcement were to go out to look at a zoning violation that someone had erected a new structure that is not compliant with building code or zoning code, and we were to get the written approval of the property owner, we would go to make the attempt. If we were met essentially with essentially opposition, we would then come back. We would then talk to the property owner again and say, your tenant is denying us access. If the tenant and the property owner were to not essentially come to a mutual amicable agreement, we would then go to the court and request an inspection warrant, which would be granted if the property owner was providing us written consent and approval. So, I mean, we'd have to kind of go through the systems, the checks and balances, which we have to do for other situations when it comes to code compliance.
I also would think it would be governed by landlord-tenant law as
Okay.
well.
Well,
So-
the risk might be more to the owner
But I
than
think
the
we're
city.
hearing from Nick that the
let me-
city's going to act responsibly in a situation like this.
So is there concern on the city side about this language?
Not from us, no.
Okay. So if you would like to propose a change or something, we can look at that.
I mean, I don't think there are going to be very many cases that are going to pose a problem with
Okay.
this. But it did kind of catch my eye that, if I were a tenant, I would be, concerned about someone entering my property. And hopefully the owner would tell me, but one never knows.
Okay, let's move on.
I have a question on page 31. It says, this is 1401-040, see the zoning administrator at their sole discretion upon written request by the applicant prior to the end of 180, may provide a one-time extension for 60 days. Is the benefit of the time limit just that zoning codes change and we don't want projects sort of sitting in the queue for a long time? And then, it eventually, it's still in the queue, but it over time, maybe it is no longer in alignment with zoning code. Is that the whole point of having the time limits?
Yeah, we don't want people to be able to vest under some of the old requirements or limitations.
Okay, all right, that makes sense.
Okay, next.
1401-050 says, unless otherwise approved in the conditions of approval, any permit shall expire in 2 years. And then it later on says, it talks about a building permit. And I'm just wondering, as a reader, would it be helpful to explain what we mean by that word permit in paragraph A, that it is not a building permit, it's some other kind of permit?
So the reference to the word permit or entitlement is that we issue design review permits and obviously other entitlements. And so because we do not have this section in our code, there are some entitlements that have been issued in prior years where a condition of approval was essentially missed by staff and the essentially the hearing body where they do not have an explicit expiration date. So we have some until they take essentially another action and are awarded a different entitlement. They essentially have the never-ending entitlement that they could come back and re-unearth. Now, not for the building permit component, but for the entitlement. And you should want to have sunsets of essentially those. I mean, you're entitling someone to a right that's not 100% vested by essentially just an over-the-counter permit. And so you don't want to kind of tie the land to something like that. So that's really kind of what it is it's not really ever going to be something that we expire, because those provisions for building permits are in the building code for expiration dates. This is really tied to anything that's a planning permit.
I think that would be really helpful to say something to that effect. We're talking about a planning permit or a design review permit or an entitlement permit. And then that, like you said, expires in 2 years unless they have what is it? They have been issued a building permit. I don't know, I think that would be clear.
All right, well, you could bring that up as a potential friendly amendment at
Just
the right time if you'd like.
Permit won't vest them.
So,
You can always
Next
ask
item?
for an extension.
No, it talks about it later though.
Yeah.
I feel like you might have many more items. Is it just a few more or is it many more?
I'm looking. Under preliminary reviews, there was a section on page 36 that says the planning commission is legally limited in the type and amount of input they can provide at this level. Typically, comments are focused on the identification of potential uses, which may be raised during consideration of a formal submittal. And so there's a restriction on what the planning commission is allowed to, what their input is. There's legal limits on their input. And I'm just wondering, does that restriction apply to staff level review?
So it's because it's a requirement of SB 330, so the preliminary review requirements. So we're allowed to provide essentially high-level comments and feedback that's essentially prescribed in the existing code. So I guess I don't understand, the staff's review, it's different. Staff's review will always be reviewing it for consistency and completeness. Those are two different terms, as we first do a review for completeness to make sure that the application has all of its defined requirements as a part of our code and our submittal criteria that's published on the city's website. And then once that review has concluded and we deem it complete, we then go into consistency review.
Which then goes to the planning commission?
Yes.
Okay,
So
I think that makes sense. So there's really two steps.
Mm-hmm.
Okay, that makes sense.
This is what used to be called a study session.
Right.
So it's the idea is to bat around the ideas and
Okay.
not to make decisions or to get into the details. That's an actual hearing, and as Nick said, under AB 330, there are 5 hearings. So you have to be careful not to overcome that.
all right,
That's a way around that.
All
Well,
right.
I mean, what the staff is doing and what the planning commission is doing are two distinct things, right?
All right, let's keep going.
Yeah.
Okay, I have to bring something up that I really had problems with, but, so I don't know if this is a question or a,
We're in discussion. So
We're in discussion now, so
okay,
in the future, I'll ask you to bring your questions at question time or talk to Nick in advance, but go ahead, please.
all right, so under 1401-100, this is the appeal procedure.
It's page 36,
This
right?
is page 36.
Right.
So it talks about decisions may be appealed. And section 1 says decisions, let's see, decisions by the staff shall be heard, let's see, hang on a second, sorry, appeals of decisions by the Development Services Department staff shall be heard by the zoning administrator, and the decision of the appeal by the zoning administrator shall be final. So I had a little bit of a problem with this because I think due process is really important, and, you know, people should be able to appeal and have someone who is not the original person who made the decision adjudicate this. So it almost sounds in that section like staff is adjudicating their own decision.
No, I
Because-
think Nick clarified that staff are the planners who you meet
No,
with. and
I know.
Well, so
I
he's
get it.
acting in a quasi judicial role when he is the zoning administrator.
And
Do
it is
I have that correct?
noticed, and it is a public hearing.
Yeah. So,
That's due process.
so do you have a proposal of something you'd like to change?
Well, okay, so Nick is not staff. I think this is what you're saying. So someone is.
He's
is-
both. He's both staff as well as in that role, he is I believe it's called a quasi judicial
The
official.
hearing officer.
Yeah.
The hearing officer.
Staff determination that it's zoning administrator, and that decision is final. So there is due process.
Okay, so here's the thing. Staff and the zoning administrator are, you just said it, they're all staff, right?
So I think what we're really getting hung up on, I am a city employee. I am staff of the city of Los Altos. I am appointed by the city manager as the zoning administrator. My purview is governed by whatever the Los Altos City Council adopts and governs me with by the code. Stephanie, the Deputy Director of Development Services, when I do not look at administrative design review approvals, actually, so that's a little bit of mincing words. Those are 500 square feet or less of design review. Quite frankly, I don't have time anymore at this level of my position to look at any of those. Now, if there's something in conflict that I have to help kind of mediate as the zoning administrator, because staff has the ability to elevate anything to me, just as if I have the ability, if I'm uncomfortable, which I have done, elevate items to the planning commission for their purview. Same to the planning commission to the council. It's kind of the hierarchy of the zoning code, essentially, is that you can continue to keep on elevating it. But so when administrative design review occurs at the staff level, I am not seeing it. If an appeal came forward, it would be the first time that I'm hearing of the appeal. When I'm taking action as the zoning administrator, I do look at that ahead of time because I'm taking the action and I hear it at a public body. My decision can then be appealed to this commission. So, I mean, the due process is there because we're actually providing essentially the challenge explicitly in the code. I mean, there are some jurisdictions, though, that have the never-ending appeal cycle, though. And I can tell you it's quite cumbersome, and it's not really kind of a best practice because we want to have finality with our decisions.
So
It
do you have a
seems-
proposal that you'd like to make?
Well, if there's an appeal and it goes to the zoning administrator, it's an appeal of an administrative discretion. The decision of the zoning administrator shall be final. That's what it says.
Yes, do you have a proposal?
Yeah, so my proposal is, I think that if the staff does something and the applicant wants to appeal it, it should not be appealed to staff. I mean, they shouldn't be adjudicating their own decisions, and you can argue that the staff and the zoning administrator are not the same, but they're in the same office.
Can I make a suggestion that we get a sense of the rest of the planning commission? Because I think we're spinning our heels on this one.
Yes.
I will tell you that as the proponent of the motion, I will not accept that as a friendly amendment, so it would have to take the
I
form.
will not either.
Okay.
I have no issues with this.
All right.
I don't know
So,
about others, but
so make sure I recognize you guys, just so we
Okay.
keep things going here. So, okay, Kate, so it sounds like there's not really, are there any, no support from anybody on that one? So let's move on to the next one, please.
So under 1401-130, we had a long discussion in an earlier meeting about
Hold on, 130, page 38.
about public noticing requirements. And I think, where it landed is if something is done ministerially, if there's no discretion, there's no hearing, right? There's no public notice.
Is that a question?
Yeah, that is my question.
Is that correct?
So ministerial actions, no, they do not. We do not allow for ministerial applications to have public notices. It has to be a discretionary action.
And it came up and it has been discussed a few times with ministerial ADU permits, and there is no appeal. And so trying to give notice for something that cannot be appealed seems that
Right.
it's frustrating for the residents and the neighbors and everybody.
can I?
So,
I believe
Go-
we discussed this at the ADU meeting, and we have no rights to have notice. So I think we're revisiting something we already got an answer to at that meeting.
thank you.
I don't think we did get an answer at that meeting. I think what I heard at that meeting is the city doesn't want to notice projects that are ministerial. They don't want to, but they could notice.
No, my understanding was, and correct me if I'm wrong, we cannot require you to give notice for ADUs, for example.
That's correct.
Yes,
Wait, the question you asked him was, we can't require, but we can elect as a city to notice ministerial projects.
No.
No.
So-
Why is that?
Because it would be requiring it.
It's state law, I believe.
Yeah.
So, okay, so is there something specific? Are you saying you would like to?
And this was already addressed at the council level
Yes.
as well, and we went round and round with, why would you give notice to?
The mayor is shaking his head. So are you proposing that we do something that violates state law? Like, we can't do it?
You know what? I want to know if that would violate state law. I mean, would it
I believe-
violate?
Hey, we're
okay,
revisiting things we did months
I
ago.
got it. Okay, so Nick, is it a violation of state law?
It is a violation of state housing law. The city is covered by 80% land area of housing. I do not know where this would be applicable for anything. And frankly, we do not have staff time or the resources to notice building permits,
Okay.
which is what you guys are asking us to do. What I would say is that the city council has discussed this, and the planning commission are not policymakers. They are to develop whatever the council has directed, and this is beyond the scope of what the commission has been green-lighted for, as the council has already taken final action to say ministerial permits would not be a public notice requirement.
Okay, all right. I mean, I think that is clear, that it's not, we can't, it's illegal, is what you're saying.
Okay. Next.
I think that's it.
All right. Does anyone else have any other discussion items? I'll look to my right.
I had a couple.
Commissioner Ahi, please go ahead.
So under the appeal procedures,
Could you tell us what page you're on?
oh yes, 36,
Okay.
1401, 100, number 2. So there was a situation I think earlier this year where an applicant made an appeal. It came to us, and then I think it was a situation where we couldn't, or we had direction, but we decided to deny it so that he could just go straight to city council. And I thought that that was kind of a waste of everyone's time, because essentially I feel like us, unless we're making the final decision, I feel like it's always going to just be appealed to the city council. So I don't really see why we would have to be the in-between, because if it's something that they don't like, they're just going to go straight to the city council. So I didn't know if other people felt that way, because that's how it felt at that one appeal
It
that
seems like
happened earlier.
it seems like we could, if we approve it, then it doesn't need to go further. It's only on the rejection
Yes.
that it would go further.
But I think in that case, he actually wanted us to deny it so
Right.
that he could go to
So
the
he could
city
skip it.
council. So I don't know. I thought that was kind of because
You-
we saw a situation like that. So I don't know if anyone else.
Was that because he didn't want it approved with conditions?
I think, if I remember correctly, I think it was something involving the setback, that basically he wanted to have a variance on a setback. And I think that we wanted him to work with staff, and he just wanted to go straight to the city council. So I don't want to waste staff's time by having it come if someone's just going to eventually just appeal it and go to the city council. So
Let's ask
yeah.
Assistant City Manager Zorns. It's a long title, by the way. What are your thoughts on this?
So I think that one was a little bit specifically interesting. I've never seen someone request to be denied.
That situation that
Yeah,
occurred. Yeah, that was a little.
I also believe it was a 6 person commission at that time. I believe we had an absence, so I think there was essentially an impasse in it. So a split vote is essentially it's a hung jury, so it essentially has to kind of keep going round and round, which is I think what we kind of did, and then I think he kind of just became frustrated and asked to be denied so that he could move forward to the council. So I don't really foresee that situation happening again. Commissioner Ahi is correct, is that some people might think that they'd have a better shot with the council. But I mean, any decision of the zoning administrator should really stop with the decision-making body for land use, which is the planning commission.
Is that acceptable?
Yeah, I mean, I could see it both ways. I could see it leaving it in there, and I could see us just having it go straight to the city council if they want to appeal the zoning administrator. But I mean, whatever the commission wants to do on that. But I could see it going both ways.
Are there people who feel one way or the other? Go
I
ahead.
would leave the language as it is, because I think the process is important to go through the different steps. And I imagine council likes having us take a look at it before they do.
Yeah, hopefully we can get rid of some of them.
I agree, that
Yeah.
particular unique situation.
It might have
but-
been a unique, yeah.
That's
And
my
then
feeling.
the only other thing was on page 38. So administrative modifications of standards. On letter D, it says only one administrative modification shall be granted, but I don't know, the way I read it, because of the items, lot area, floor area, setbacks, I feel like there may be multiple items that are related if one modification is granted. So I wasn't sure if maybe it should read that, more than one administrative modification of standards may or shall be granted if they're related to one another. Because I think if one thing gets modified, it could affect something else. And then I don't know if it's like, oh, well, it was just one. We can't do a second one. So I just saw that maybe if they're related to one another, we can do more than one.
Any commentary, Mr. Zorns?
No, I mean, that's kind of a commission preference if they think it's best for land use approvals in the future. I wrote it to kind of try to be as conservative as possible, but be able to provide some flexibility for some of the random abnormal circumstances. Some people aren't going to want to go through the AMS process just by virtue of that it's not going to get them much relief, and they obviously have to pay for a significant planning permit for something that might be super minor in nature. But I can think of specifically like a setback of a fence from an existing wall structure that, I mean, we were talking about, 6 inches of deviation. And I mean, the individual now has to kind of like literally crawl between their fence and their AC unit on the side of their house, which is kind of silly.
So why don't we see
Yeah.
at the time if the motion and seconder want to consider that one? Those are your only
Yeah,
two
that
items?
was it.
Any more down here or no? Any more over here?
I actually do have a question for Maris on this, and perhaps from Nick as well. If I understand correctly, this is something at the time of the application, not at the time the thing is being built, is that correct?
That would be correct, yeah.
Yes.
Yeah. Okay, so, and the question here is the completeness of the application. That's what this section is about. And it seems to me that whatever facts there are should be known by the time the modification is coming up. In other words, the modification might not be just one thing, but it might be several things. So I think that, I see Maris's point, but I think that the way it comes up, that would sort of be worked into it. In other words, the modification wouldn't just be for one element, it would be for, if you modify this, you have to modify that. And that entire thing would be subject to approval or, whatever discussions might lead to. Because it would be a negotiation as well between the applicant and staff before any determination is made. So,
Okay.
Maris, is that?
Yeah. I think you're right. I think at first glance, it seemed like it was just one thing, but I think you're right. There's some things that might be related.
Right.
Once it happens.
Right.
Yeah.
Right, and we understand that the housing administrator, zoning administrator, does understand the sense of discretion, as in, it can be wide.
Yes.
Yes, so,
Okay.
all right.
So are you indicating your
I-
interest in?
I don't think it has to change. I think
Okay.
it's fine the way it is.
Okay.
Yeah.
All right. Are there any other items for discussion?
I do have one quick thing.
Please.
I do have some small grammatical things that I will communicate separately, but there is one question that is sort of substantive, and so I want to bring it up in chapter 14.02 definitions under office administrative, and I'm not sure what page that's on because
1402, you said?
14.02, it's the definitions, it's that hideous one, and it's under office administrative. which
Page
looks like
52, possibly?
52, possibly, could be possibly on page 52, yes. Okay. And it has to do in the very last line where the part in red where it says real estate companies, estate planning, and computer support. That caught my eye because to me, estate planning is a legal specialty and law offices are already included. I was wondering if it meant, if there's something about, if there's such a thing as an estate planning office that I've never heard of, or if that meant something like financial planning. And I was going to suggest that perhaps that was what was in mind, or something along those lines. And the reason I bring it up is because it would be a substantive change to change from estate to planning to financial. So I'm not sure what that, it just seemed incoherent. So my recommendation is some kind of a change that makes,
I mean, saying examples include, so it's
Yeah.
a long laundry list.
yeah, but it, but I'm not aware that there's such a thing as an estate planning office. And law offices do it. There's no such thing as a separate estate planner, but there are financial planners all over the place.
Right.
And it seemed to me that that might be,
Mr. Zorns, any,
I think it would be either appropriate to strike it out since it is just an example
Yeah.
include, or we can just change it to say financial planning. Again, it's the commission's kind of prerogative to kind of say what's essentially going to help further implement that an office administrative use in the future will be determined to be either those kind of explicit examples, or it's a little bit more, we'll look at it, a little bit more objectively in the future. So financial planning, or just strike it out. It's up to the commission.
or
to you.
just financial? I mean, is financial covered here anywhere?
I think banks are, but
Banks? Financial planning's fine. You're the motion maker, so what would you like to accept from yourself?
I'm happy either way.
Finance.
And I think my recommendation would be to leave it up to Nick, whatever he would like to do. It's just, I think that does need to get cleaned up one way or the other.
What would you prefer?
Given that we do have some financial planning services in the OA district now, I'll change it to financial planning.
Okay, so we'll make that a friendly amendment at the time.
I would probably phrase it financial advisory.
Yeah,
It's
okay.
more implicit.
Okay, great.
Right.
On that,
All acceptable.
can I bring something up on that?
Are you done, Eric?
I think I am, yes.
Okay, go ahead. Go ahead, Commissioner Disney.
Just on that same page, there's a mention about a museum will be an art gallery, something to that effect. I'm looking at art gallery. It says means a business or place which.
Says shall have the same meaning as art gallery.
Correct. But if you look at page 43, art galleries means a business or place which displays a variety of art and/or artifacts for viewing or purchase. And I was thinking of that museum-type place on State Street that was kind of like trying to be an exploratorium. It was like a hands-on science museum. And I thought, okay, well, that's a museum, but I don't, like a science, hands-on interactive museum. And I don't think that would fit into the art gallery definition, because in that type of interactive space, you don't have artifacts for viewing or purchase. I don't know. I just wonder if we could
Is there a reason?
define museum.
Yeah, Mr. Zorns, is there a reason why that's there? That does seem a little bit odd, because museums are not art galleries necessarily, but.
Art galleries are museums that are enclosed in the gift shop.
So we have other areas of the rest of the code that do use the term museums, and I'm not opening up those sections yet. So it's kind of giving a little bit of clear delineation for the other code sections, because I can't really kind of unpack everything without
Got it.
bringing in like 5 other chapters.
You're using it, it has the same controls tied to it that the art galleries do.
Correct.
Okay.
Yeah.
So I agree with you. It's a little weird, but I understand why he's doing that. Does that make sense?
Not really. So we agreed that the museum is not the art gallery, but you're saying for the purposes of just how you're going to treat a museum, it's going to be treated like an art gallery. So we're just linking them,
Well, because,
essentially.
yeah, because it's sprinkled throughout the code. And so he would have to go in and change
Right.
every reference to that. So,
Okay, all right. That's fine.
but that's a great point, though. That is a little odd. All right, so I think we're are we done with discussion? So there were a number of possible friendly amendments. So I'd ask that if you wanted a friendly amendment that we just discussed, that you now speak up and ask the the motioner, Vice Commissioner Steinle, as well as the seconder, if they're open to that. So Commissioner Disney, I think you had a few.
Okay, so I think the few were adding something in here that would kind of clarify ministerial, administrative versus discretionary.
Okay.
You know, what are the different roles? And I don't know how to put that into a motion, but something like a chart that would clarify what those words mean, so people understand.
So to the motioner.
I don't think I would accept that. These are standard terminology in these areas, and I don't think that it's necessary to do that. And charts make it seem much more important than it is. So no, I would not accept that.
Okay. So were there other ones?
The other one was under variances. I think it reads better, it's clearer. If what we call a variance is something that goes before the planning commission, then I think we can strike the word zoning administrator from 1481.040.
What page is that?
Page 60.
Page 60.
Well, I will point out that the very variance that we were talking about is an example of what Nick brought up as the issue, because there were two variances requested there. One was an administrative variance, which was granted, and the other was an actual variance, which we did not grant. And so that's a case where the Nick would end up making decisions that, if it's a real variance, would be made by us. So I don't think that, I do think it's appropriate to include the zoning administrator there. It might be possible to clean that up a little bit, to say, for example, the zoning administrator in the case of an administrative review, and the planning commission otherwise, or something along those lines.
I think that
to
would be
clarify the
helpful.
roles. That I would be fine with, but I would not agree to striking the word zoning administrator from that.
Is that acceptable, Mr. Zorns?
Can you clarify about what you're recommending to modify?
Well, the zoning administrator, in the event of the ministerial administrative, the administrative modification of standards, which I think is the one part, and the planning commission in any other circumstance, which would be the true variance, or the major variance. Or if you wanted to say zoning administrator in the case of a minor variance, because that has particular meaning, and the planning commission in the case of a major variance, something that establishes the areas in which both work, but that retains the.
I don't think we have minor variance, though, as a defined term
So
for that.
Yeah, the
for that.
commission's starting to change the entire kind of structure of what was put together. We're talking about pulling out the AMS because it wouldn't really have a place in this ordinance.
which section, where would this be that you're proposing
Well,
this?
the one where it's.
Right, it's the 1401-120 administrative modification of standards in the
Right.
event that the zoning administrator,
That's the so-called minor variance.
What page?
page 37.
Yeah, I need page numbers, guys. I can't see this. 37.
Okay, well, 37 and 38. The
37 and
opposite part of the
38.
piece is
So
on
you're
38.
suggesting,
No, this would be a change to the actual thing that she is suggesting, changing the language in, is the last part, on the last page. So that would be page 60, or 59 and 60, and this is the variances, chapter 14.81. Okay,
59 and 60?
yeah.
Could we just say something like a variance may be granted provided that the zoning administrator pursuant to 1401-120 and the planning commission pursuant to 1481-030? So we're referencing the sections that the approval relates to.
We just need to know where you are. I don't, I can't,
I'm on the same page.
which,
I'm on the same page that we've been on the whole time, which is the page 60, under findings and decisions related to a variance.
okay, Eric brought us back to 37, but now we're back to 60. So what is the specific friendly amendment?
Because, okay, okay, so
I think if I can
Yeah,
help
go
out with
ahead.
that. Because I would be inclined to agree with you if we can get the language straight. A variance may be granted provided the zoning administrator pursuant to section, and then whatever the one that is the administrative modification section, or planning commission pursuant to this chapter, right, or whatever.
Yeah.
Nick, is that a problem, or is that, what are we screwing up here?
Everything? Yeah, I wouldn't recommend that. If anything, I would say remove the zoning administrator from the variance chapter. If the commission wants, I can explain it, but you're mixing together two very different things,
that's
which
fine.
if
That's fine.
if just at the base root, what I want to say is, if you look down the rest of the chapter, you're talking about a variance that runs with the land.
Right.
That's not a provision of the administrative modification of standards.
That's true. Okay,
That's why
fine.
it's different.
Then let's just get rid of zoning. If that works for you, okay.
Well, but
then-
Actually, I would rather, as a second, I'd rather keep the zoning administrator in there. So somebody
Okay.
else can second it, but no,
I'll
I would
second
leave
it.
it as it is.
well, I thought there was a problem with removing zoning administrator from there.
Yeah, which is why I was saying, as I can re-explain it, is so I'll give the very real hypothetical, is if a 4-unit subdivision of townhomes is proposed, and for some reason if the lot has a grade differential from essentially the high point to the low point with a slope of like 5 feet, it's most likely not going to meet our height requirement. It most likely will need to obtain a variance for height.
Right.
So I'm going to take final action on the 4-unit townhomes of the design review. And when it comes before you, you will see an elevation drawing and a topo survey, and that's it. Because your purview is only for the variance component and nothing to do with the design review. And that's because as a part of our housing element, the council granted me 5 units or lower will go directly to the zoning administrator for design review,
Right.
which is different than a variance. However, again, for a variance, they're still going to have to make all of these same findings in order to be approved from the zoning administrator level. We're still bound by that. So it's just you'd be bifurcating the decision-making of the two separate entitlements, and it would just become cumbersome to the application. It would also be somewhat running a risk of the fact that we only have 3 public hearings, and I would take action on 1, you'd take action on 2, and you'd have to make that decision in that meeting because their appeal counts as the 3rd.
I had not understood that as meaning that in that way. What I thought was that there are 2 different kinds of procedures, one that's yours, one that's ours, and that whichever one it is, there is a procedure for following that. So I didn't read it the same way. If you read it that way, then I think that we have to go with your preferences. However, I did read it very differently, and so.
That's also partly one of the reasons why I didn't want the variance section to be in this, is so that you are reading it when you're, even for applicants, you're not going to go and kind of down the list and thinking, oh, well, I just read this. I mean, that's usually what happens. So
Right.
you try to separate the chapters to kind of keep people oriented to that specific provision versus kind of blending everything together.
So then would you like to?
I think I guess Nick, the question is, which eye do you want us to poke out? Do you want to get rid of zoning administrator, or do you want to leave it the way it is, or what would be your preference?
I think he said you'd prefer to leave it the way it is.
Leave it the way it is, okay? And Susan, that's,
Yeah.
yes,
I'm fine
okay,
with not
then,
making change.
then fine.
Okay.
I mean, if that's, I had read it very differently, and it seemed to me that they were operating independently of each other, and so, in
Okay.
that case, then let's leave it the way it is. That's fine.
Well, how do you
All right.
reconcile then C1 that says a public hearing shall be required with the planning commission on a variance application, period? Maybe that needs to change. that a public hearing shall be required with the planning commission on, when, it exceeds so many units. I mean, why?
The variance is defined by law, so that it would be an application for that. So that's already there.
Okay,
That's-
so I'm going to move this forward.
Yeah.
The friendly amendment was rejected. Are you proposing a different friendly amendment?
No, I asked a question, and I didn't get an answer to it. I mean, I don't understand how you can reconcile C1, because it says.
I have no idea what page you're on or what
Okay,
item you're referring to.
I'm on the same, I'm in the same area I've been in, page
Pa-
59, C14.
Okay, we were on 60 a minute ago, so we're going back to 59.
14.81.030, submittal requirements and review. C, notice, hearings, and appeals. 1,
Yes.
a public hearing shall be required with the planning commission on a variance application. So if someone goes and submits for a 4-unit building, it's going to the zoning administrator, and they're asking for a variance of some kind, then it's not going to the planning commission.
I believe it's not a variance. I think Nick discussed that,
It's not a variance.
And it's not a variance application, which is a specific thing.
which is different.
Yeah.
So I think, again, we're revisiting.
So,
Previous
They are
so
two different things. They're just two different things.
okay. So, would you like to propose a change or?
If they're two different things, then why is it in this section?
Could you
under-
help clarify,
Yeah.
Mr. Zorns?
No, I mean, I think we've heard the answer, and it's I'm confused, because we're saying they're two different things, but then we're leaving zoning administrator in we're saying that the zoning administrator is going to grant a variance.
Okay, go
I don't
ahead,
know if you
Commissioner.
find that
Yeah.
con-
This meeting, I think, has sort of gotten to the point, I think at some point, we just have to accept the fact that we have professional staff here who have drafted this very carefully and with the help of the city attorney. And we can nitpick a lot of things, but the fact is, there's so many interconnecting parts here. Why we can ask big pictures, we've asked a lot of good questions. I think we need to move on and respect what they've done.
And I will add one thing to that, which is that the parts being discussed are from two different sections, which have different purposes. So they don't necessarily discuss the same thing in the same way.
Okay, so any other proposed changes or friendly amendments? I know Maris had a couple of ideas. Do you want to suggest them, or did you feel like they were answered?
I think both of them, I think the consensus was just to leave it the way they are.
Okay.
So I think it's fine.
Okay, and then the last one that I had was around the financial one, which I assume you would, since you were proposing it, that you would accept the friendly amendment there.
Yeah.
Okay, and did you,
Can you remind me, I'm sorry, which one is that?
the one about museum, or financial,
Yes.
what do we call it? Financial?
Financial advisory. Yeah, right.
Okay, so that one is accepted. So I believe the motion, as it stands now, has one change to it. Is that correct?
I think so.
Okay. And it's acceptable to both the motioner and the seconder?
Right. Since we
Okay.
thought of it.
Since we thought about it. Okay, so I think, unless there's anything else, I think we're ready for a vote.
Commissioner Ahi,
Yes.
Commissioner Disney,
Yes.
Commissioner Mensinger,
Yes.
Commissioner Steinle,
Yes.
Vice Chair Roche,
Yes.
Chair Benenato.
Yes,
Motion carries unanimously.
thank you. And so was that clear, Mr. Zorns? We got everything? All right, great. Thank you so much. I'm sorry for the discussion. In the future, we are going to ask all of our questions. I would recommend that if like I did today, I reached out to Nick and Stephanie with a few questions, and I got those answered, so we don't have to spend an hour going through trivial things. So I'd ask that you please do the homework up front so we can move this thing along. And then we can spend more time on the discussion portion and debating issues if we'd like to. So thank you again to everybody on the staff for the work on this. We're going to move on to discussion. And it is item 4, the Planning Commission Work Plan, which I don't believe we had one before. So this is exciting. And as my understanding after checking with Nick and Stephanie was that this is just a discussion. There's no public comment. There's no vote. I believe that is correct. So do you want to walk us through it, or how would you guys like to handle this?
There is public comment on
Oh, there is?
discussion items.
Okay.
So only information items when they do occur on your agenda are not really public comments.
Oh, maybe
for
I
like an
misunderstood
active,
earlier.
Like engagement, essentially, yeah.
Okay. So do we start with the presentation and then we'll move on to public comment?
Yes, so I don't have a PowerPoint presentation. I'll just briefly kind of cover what was provided in the memo. So in preparation of the city council meeting review of commission work plans early next year, the planning commission should review and discuss the draft work plan provided by staff. Planning commission's work plan is a little bit different than the other commissions in that your role and responsibilities is as both a decision maker and an advisory body to council on permits and land use decisions, which is different than the other commissions. So you'll see the first portion of the work plan is really kind of that function, which is housing element implementation in the form of code amendments and development project review. There hasn't been a lot of development project review that's come forward in the past year, but we do anticipate some more coming forward. And then the kind of second portion is the 2024 work items. The first is the general plan safety element that we're currently working on and would come before the commission for review and recommendation to council. And then next year, the comprehensive general plan update, which would be the other elements that do not include the safety element and or the housing element, which would have both recently been updated. So that's the draft plan if you guys want to talk about it.
All right. So should we move on to clarifying questions before public comment or?
Yes.
Okay. So this is clarifying questions, not discussion. Are there any questions about the work plan in front of us for staff?
See if I can do this. This is on.
You press and hold until it turns green.
Yeah,
No?
there you go.
Gotcha, finally. On the review of this comprehensive general plan, can we be given an area of where it's going to start and with directions so that we can do advance, those of us that like to do this kind of thing, in advance, knowing what is going to be planned in that area, or where you're going?
So we haven't even started yet. We would, do an RFP for an outside consultant that would be reviewed and approved by council, a proposal, and then we would start to work through the different elements. So there's not really anything we could provide you to plan for, other than the existing general plan would be replaced with a new comprehensive update.
Yeah, the existing one's woefully inadequate. Did I say that correctly? It's politically correct. It's missing elements. It's I don't know. It's from 1980 or.
The actual contents of the text is, yes, it's well over 3 decades old. They kind of did a rebranding and mishmash of the document, which is partly one of the reasons why it's necessitated to kind of peel back the layers and do it as the comprehensive update.
And this is probably months away then if you have to do an RFP.
Mike?
Yeah, what the commissioner was asking is it's months away. Yes, however, we are already underway with our safety element. So we will be doing our second necessary public engagement in November. So that will come to the commission in earlier next year, probably February or March. for a recommendation to the council. I will say safety elements is kind of one of the, kind of like one of the most like straightforward ones because it's very prescriptive by state law and what's required for emergency access response, all that fun stuff. And it is different as it's kind of the overarching policy of the city. It's not necessarily like the implementation plans like some jurisdictions then have a subsequent document that's even further essentially. So that one will come to the council early next year or the commission early next year.
Any more clarifying questions on this side? Good? Everybody? This side? Nothing? I do have one. Mr. Wing referenced the code circulation element, Mr. Zorns, and I was curious if that was something we needed to worry about next year.
Can you repeat the question? Sorry, I didn't hear that last
The
part.
Mr. Wing had referenced the code circulation element in a public comment, and I wasn't sure if that was something that should be in our work plan or not.
So the circulation element is an element of the general plan that will be updated as part of the comprehensive update.
Oh,
All of the elements will be
of the general
updated.
plan.
Correct.
Okay.
Yeah, the circulation element, it could be one of three names: circulation, transportation, or mobility. It kind of just depends on the branding of the city. That's actually going to be like the really meaty part of the comprehensive general plan. Noise and air are kind of just, scientific kind of analysis that's necessary for the document. We'll have environmental justice. That's another requirement. And then really the kind of meat and potatoes is going to be the circulation, which actually requires us to do really in-depth transportation network analysis, which is totally different than what like the CSC did with the Complete Streets Master Plan, because that's talking about actual complete streets and the network for bikes, peds, all that fun stuff. So it's a totally different analysis that will be very involved
Okay.
in general. Yeah, and then that will actually be our true kind of full deployment of VMT or vehicle miles traveled, which is the full conversion from LOS to VMT, which is required of all cities now.
Okay. So if there are no further questions, we go to public comment. Yes? Are there any speaker cards?
Yes, we have one speaker card from
Okay.
Jim Wing.
3 minutes on the clock, please. Is the clock still over here? I can't see it.
I'll be short, no clock needed.
Okay.
But for the record, I'm Jim Wing. I'm a 56-year resident of Milverton Avenue. I'm really here, first of all, to thank staff for, it's directional. Thank staff for.
Do I need to turn the mic on or is it on?
Well, you have the white switches where it says lectern.
Let's try it now.
Okay?
Yeah,
Better?
that's better. Sorry,
We got it?
sorry about that.
I can move around.
Rookie move over here.
Okay, so basically here, I wanted to give you a little bit of color on the circulation and also the relationship of the, what we call our streets. And we call them local, we call them collector local, we call them collector and arterial. So we have four. Now, each of those four actually trigger in the California Vehicle Code different sections. And for most of us residents anyway, we're worried about the traffic calming events anyway. Now, keep in mind, each one of them kind of has different things. Because when you look at speed, local, 25 miles per hour. You look at collector, or it's local and also local connect collector. You look at collector, that speed is driven from the 85 percentile speed calculation that is done. Arterial, it's the same thing, the 85%. You look at something like speed humps. Speed humps are allowed on local and they're allowed on local collector, but for when you go to a collector, it's speed tables, and that's actually what it should have been. Speed table on question to start out with, and that's what it is now. And of course, the arterials, there's nothing there. So there are several things like this that you have to, when you talk of these, you have to relate to the California Vehicle Code. and kind of get a feel, or somebody does, as to which we're buying. Now, probably near term, or it's always been on the table to do one-way streets in the downtown triangle as one option. We don't have any data to know whether it even works or not yet. But basically, you're going to have to tweak the code a little bit to make sure that you can work with that and change a normal street to have a so-called one-way option to it. It's not straightforward in the California Vehicle Code. So I just want to give you a little bit of color, and to hopefully, it'll be a while before I'll come back, but we'll see what happens when you get into the heart of this. Thank you.
Thank you. It's nice to see the person behind the emails, the infamous Mr. Wing emails. So welcome. Thank you. All right, so we're not taking any action on this item, I believe, right?
No.
So shall we move on to the next section?
What is the next section?
Commissioners' reports?
Oh, I think, can we talk a little bit about the work plan? I mean, we
sure.
really didn't discuss it.
Oh.
I mean, we did discuss it, but
Right,
we
but
didn't discuss anything that's not on there.
We're not voting on this, right? So, okay.
Yeah, it is an opportunity for you if you discussed among yourselves you wanted to
Okay.
Potentially add things or delete things. This would
Okay.
be the time.
So, sorry, I earlier I was told we were not going through that, but so why don't we open it up for discussion?
Okay, I'll go first. So this looks great. I have no problem with this. One thing that I would like us to do as a commission is like more feedback. Like we do things, we make decisions, or we make recommendations and decisions. And it'd be really nice to look at the result of what we recommended or what we decided by looking at projects in the city or even looking at projects in other cities and doing kind of the drive-by as a group and saying, hey, this is a good project. How did this city or how did our city achieve a good result here? What did we do right? Or here's something that really, doesn't seem to be working. Could we have done things differently? So I think it's really important to have that feedback mechanism because I think we're human and we're going to make mistakes. And I think it's really important to build some kind of self-correction into the work that we do.
So some sort of postmortem after, we pass objective standards or something and we go look at a project. Is that what you're suggesting?
Yes.
Okay.
Or more than one project.
Do you want to
Maybe
add to that?
Yeah, I was going to say, actually, we did that several years ago. We didn't go physically look, but I believe staff made a report to us and we looked at a couple projects, if I remember right. I think it was during Zoom time, so we weren't going anywhere. But that is something, and it was helpful.
It was
So-
pre-Nick. It was
Yeah,
previous
pre you guys,
administration.
but
Well,
that
and
was
I'd
helpful.
like it to be like a process whereby we could suggest an address. It wouldn't have to just be coming from staff, but we could say, okay, look, there's something on El Camino that I just think is a horrible project, and I want to know what the rest of you think and how can we in the city of Los Altos avoid, anything like this if we agree it's not a good project, or vice versa, it might be a great project. How do we get projects like that? So I think it'd be nice if all of us could, propose certain projects to analyze as a commission.
I'm not sure how we would do that. I don't know if
Can I make a
Stephanie or
suggestion?
Nick have an idea. Like we couldn't all go together to a place. Oh, we could? We'd have to notice it. Go ahead, Commissioner Stanley.
Well, I was
Speak into the mic.
Yeah, I was going to suggest that this is the sort of thing for which subcommittees were devised, and it would be possible to have a subcommittee, because I'm concerned about taking up staff time with this, because there would be very little contribution from staff, except they would have to be there. It would be much easier if a subcommittee did it, because you wouldn't have the Brown Act issues at that point, and the subcommittee could go and make a report and bring it back and report on that to the commission, and the commission could put in its agenda to discuss what the subcommittee had done. I mean, that would be an easy way to do it. And in the meantime, nothing prevents us individually from going and visiting something. And we don't have to do it as a group. We just have to, if we're going to discuss it as a group. And those who want to see it will see it, and those who don't care or who are familiar enough with it or will rely on whatever the subcommittee comes up with can do whatever they want with it.
Go ahead, Vice Chair.
Does this, if two or three of us went to a project that we have approved, say something on First Street, and we went out there, the project's already been approved, it's it's being sold, we don't have a Brown Act problem there. Maybe not.
No, if it's, if it's 3 or less, that's fine. But if you're,
We're 6.
We're 6 now.
oh, you're 6 now, that I forgot. Yeah, so yeah, you have to be 2 because you can't be a majority of,
But even though the project is complete and it's it's been finished, it's been sold, or it's being sold,
well, but if you're coming back to the full planning commission to discuss it, then it would still be an item that would be
Gotcha.
before you in your jurisdiction, so.
thank you.
I mean, sorry, one thing we could do is we have this section, commissioner reports, at the end of the meeting that we don't really do anymore because we don't have meetings that often. But what we could do is, one of us could just put together, I mean, I walk by the 3 projects on First Street every day. I drive by 5150 that's under construction right now. So just having maybe a general chat about this is what we approved, this is what ended up getting built, what are your thoughts? Because I do feel like there's a lack of, once it leaves us, there's basically no one talks about it ever again.
Right.
And I think that, I mean, I don't think the developer of those projects will come back and tell us the things that they learned, because I don't think they care. But I think it would be nice to hear, okay, this changed during construction. This is something you guys can look into for future projects of what didn't work, what did work. But again, that takes a lot of time. But just an informal discussion, I think, one of us, I mean, I could do it for the next meeting. Just take some pictures and we could just, show it on the screen. So
Let me, so I like this idea because it's very hard to know, like, did those guidelines that we implemented, are they working? Like,
Yes.
like are they working for developers? Are they working for, the residents who walk by the buildings or whatever? And so closing the loop on that, I think is a helpful thing. Should we maybe leave it to staff to think about what might be the best way to accomplish this, and we can come back at a future meeting and talk about how we would implement something like that?
Yeah, or I mean, what I could recommend is that if you're not gonna find any objective standards that have been constructed in the city of Los Altos. You still do not have vertical construction of any
Good point,
projects
good
under
point.
those today. However, what like the downtown buildings committee, what the planning commission did work on with Opticoast and Lisa Weiss was essentially taking all of these random ones, kind of like what's being discussed right now of, oh, well, we like this architectural emphasis of these cornices around windows, and we like this projection of this type of, offset of the building, so on and so forth. And that's what was used as kind of like the basis for Opticoast and Lisa Weiss to actually come up with those objective design standards, which are still there. And we have projects that are under review that you just have not seen one of them come before you as a commission. And so we don't have one that obviously has gone vertical yet, by any means. So there are going to be components and remnants of things that are from projects that this commission liked that we put into the code. You just aren't going to have anything physical that's truly like we're going to be able to say it's essentially what we were doing with this new provision. It's just not going to be apples to apples. What I would say, so that the commissioners that might be interested in a standard is, if you see some architectural, essentially building embellishments or kind of styles of something that's going on with like a multifamily housing development or even single family, you can send that to like me and Stephanie, and we can kind of like tell you where in our code, so you guys can start relating what the standard is or how we arrived at that, or see how far off our code is from the standards on certain provisions. And then that might help kind of orient what you guys might want to maybe change as a recommendation back to staff to kind of work on. Because that then kind of opens and orients the conversation. So you're kind of being a little bit more prepared when you do come back with your report out on, hey, saw these really cool, details, but we actually are falling short, or we actually do have it, guys. It's just, we don't see it enough yet.
So it sounds more like you're suggesting a one-off sort of thing. Like if we see something, ask you about it, as opposed to more of a ongoing educational process. I'm not sure you guys have the cycles to do that. Is that what we're getting at?
I mean, we can. I mean, these things can kind of come up as you see it. It's just, again, you're not gonna. What I think would be is if we even agendized it, I don't. What we're gonna go and do is, unfortunately, at most of the buildings, is you're gonna say, well, this was density bonus, and we tried to do that there, and they said, no, I'm not doing that, and we had to say okay, or hey, this is what the code section is, and this is how they applied it under the old section, but now it's moved, and we're still gonna be almost in an envisioning process a little bit. Is it's well, the new code would actually have this wall come out further or push back in more. So I mean, it's not gonna be as you're not gonna really be able to find an example of what our code reflects in the field yet.
What if we suggested, a tour of First Street, and we walked it together, and not all of us were involved in all of those buildings because they were before our time, but we could just have a discussion of what went well with this project or that project, or what didn't go well, or some that might be a way to start this and see if it's useful, as opposed to having. What looks good, what doesn't look good. Yeah. I don't know. Is that putting too much burden on you guys to carve out an hour or two to go down First Street?
Do we really need them to hear that?
I'd like to hear their perspective about what they think went well and what didn't go well.
Yeah,
So
I don't know.
If they've got the bandwidth, I think that would be really useful.
Yeah, I think if we were able to schedule with the commission, it's going to be a daytime thing, though.
Yeah.
Yeah, I mean, we could do that again, though, is if we're doing it in more than groups of two, it's going to be a noticed occurrence because of the composition of this commission now.
All right. Well, I think you've heard the request, and however you guys propose to do this, I know you guys work really hard, and so we're not trying to add to the burden, but I think some education for us would be a very useful thing as we start to see, especially as interest rates come down and maybe some projects get going. There might be some before us. Do you want to add something?
Yeah, the other thing we talked about at a prior meeting was it would be nice to see some of the mechanical car lifts that are going in garages.
Oh.
And seeing how they actually work and how well they work.
Do we have any downtown?
The planning commission before went to another city and looked at them.
Yeah.
And we did a noticed field trip or something, but I don't know if we have any that are in.
We do on First Street.
Oh, great. Yeah, that'd be cool if we could do that. And
Yeah, I've been to the 3 just open houses, so I've seen them. Just kind of going as an open house, but yeah, it would be. They are very interesting. So yeah, I think
the lifts or the
lift system,
okay.
The parking lifts.
Okay.
So I mean, if we can't get inside, you can probably visit on the weekend.
And I recall we have a standing invitation from, I believe it's the city of Livermore, to come visit them and check out what they did to their downtown. That's a much bigger commitment. But if the first one goes well on First Street, maybe we can consider going further. But we don't want to tremendously burden you guys, but I think it would be helpful feedback. So does that?
Yeah, I like the idea of the First Street, and I think I would love to do a tour of El Camino, because I mean, this is a really complicated area with 2 other jurisdictions and a lot of lots that are primed to be redeveloped. And there's going to be a lot of changes there. And like you said, interest rates are going to come down. We're going to see a lot of development there. And there has been a lot of development already.
Okay.
So it's,
Yeah.
it's a time, I think, to look at what's working and what isn't and ask ourselves, would our code prevent what we don't like and would it enable the things that we do like? So I think El Camino is really an important part
Right.
of the city to look at.
So I'm going to suggest we leave it with you guys to figure out what can be accommodated in your limited time. And worst case, maybe some of us could just go, or two of us at a time. Could two go and then a different two go, or does that cause Brown Act issues?
Two can go, but then don't talk to the other two. Don't talk to the other.
Well,
Okay.
You could just appoint a seventh person, then we could have three.
Well, I was going to say, the Brown Act's not a big deal. When I was on the Downtown Building Committee, we did that, and we just noticed it.
Okay.
And invited anyone from the public who wanted to join us
Without
to join us. and-
staff?
No, we had staff there.
Okay.
But,
Well, that's what I was getting at, is the staff commitment.
yeah,
The
if staff has the time.
As directed by the council, is if it's a Brown Act kind of sanctioned meeting, essentially, staff is involved in order to ensure that there's no violations with the Brown Act. So if we're doing a quorum, we're gonna have staff there.
Okay.
But it could be one staff member who I presume could also tell us about what they thought went well and what
Yep.
Right.
didn't go well. So it kills two birds with one stone.
All right. Anything else on the work plan? All right. So do we need to close this item, or are we good? Okay. So next item, commissioners' reports and comments. Anything from anybody? We had a lovely 6 months off.
I have a question. I mean, I'm sorry, it's not about the reports, but are we going to continue to have meetings canceled? I mean, what's going on with the meetings? I guess that was my,
I think that's a potential future.
yeah, maybe I'm moving
Okay.
ahead, but.
Well, if there are no reports and comments, we are on future agenda items. So I think the question is,
Are we having a meeting next in 2 weeks, or?
should we expect more like cancellations until some projects come in, or?
Yeah, so we can't predict when people will be ready to bring their project forward. There has been a considerable lull, as mentioned, in the past 6 months. The November 7th meeting will be canceled. There are no items, but there are tentatively 2 items scheduled for November 21st and 1 for December 5th. And
Oh.
those are development applications.
Wow, so it's starting up again.
Yep.
Okay, does that answer your question?
Yes.
Any other potential future agenda items? Going once? All right, I've always wanted to do this, so we are adjourned. Is that how I do it? Okay. Do I leave this here?